Yes, perfect. Hello, everyone, and welcome to Season 3, Episode 13 of ARBinBrief, your practical video guide on selected arbitration issues. ARBinBrief is produced in collaboration with 𝗔𝗥𝗕𝗙, as well as the Lagos Chamber of Commerce International Arbitration Center. My name is Vera Bykova, and I'm part of the ARBinBrief team, and I'm working as legal counsel in a leading shipping company based in Geneva, Switzerland. I will moderate today's session on whether arbitrators shall possess a technical competence, and we will explore the basis of such a duty, if it exists at all, the content of this duty, as well as the role of arbitral institutions in promoting tech-savvy arbitrators, and we will also touch upon some practical real-life examples highlighting the impact of technological competence on arbitration proceedings. Allow me to introduce our speakers that are together with us today. We have Andrea Roth, a senior associate at Wartman Mercer in Zurich, and we also have together with us Aija Lejniece, an independent arbitrator and counsel in Paris. Thank you so much, Andrea and Aija, for joining us, and allow me to kick off with a simple basic question of our discussion today. Should indeed arbitrators have a legal duty to be technologically competent in today's modern world? And if so, what are the legal basis of this duty and what is its precise content? Maybe we can start with Andrea first.
Yes, to give you a short answer, yes, I think, in my view, an arbitrator should have a legal duty to be technologically competent, at least to a certain extent. Well, there may be no such a duty to be found in the arbitration laws. For example, when I look at Switzerland, you cannot challenge an arbitrator for if they are not technological competent, of course, unless this has been agreed to between the parties in the arbitration clause or after the dispute has arisen. But without such an agreement, you cannot challenge the arbitrator. This aside from that, there may be other laws that have an indirect or even a direct obligation of the arbitrator to be technology competent. I'm just thinking about data protection laws or laws that deal with the professional duties of lawyers. And in that regard, Aija has some valuable points to add here. But even if we don't have any laws that contain such a duty, the crucial question I think we have to ask ourselves is this. If we take on a mandate as an arbitrator, we have to have, or with that, we actually say, yes, I am capable, I do have the necessary skills to decide on that matter and to govern this dispute. And in today's world, in my view, this requires that you have to have a certain technological competence. So why is that? Well, one of the expectations parties have is that arbitration proceedings are conducted efficiently, and this is a well-supported expectation. It's well supported in many arbitration rules, and thus one of the ways to have a more arbitration efficient proceeding is to have to do that with information technology. So information technology can serve or can lead to more efficient arbitration proceedings. And this is why I think that every arbitrator has a duty to have a certain technological competence, at least on a basic level, so that the arbitrator, as really that's just a minor requirement or the at least requirement to have to conduct a hearing by video conference or do without the submission of the pleadings and the exhibits in hard copy. And of course, if the case also concerns certain technical issues, then in my view, the arbitrator also has to have a higher technological competence.
So I absolutely agree with Andrea, and I'll add on to that more and more jurisdictions are becoming aware of the need for lawyers in general, maybe not arbitrators specifically, to be technologically competent. In the States right now, so you have the 2012 ABA model rules that kind of have this very broad clause requiring lawyers to be competent, so as much as that is needed for them representing a client in the case. And there are certain states like Florida and North Carolina that have now added CLE requirements in tech, and New York has added a CLE requirement in cybersecurity and data protection. So I think generally we do see jurisdictions recognizing that there is a need for this. And of course, there's also the new UNCITRAL Arbitrators Code that has a very general obligation to be competent, but we can also interpret tech into that.
That's very interesting, Anja and Andrea. Thank you so much. So I understand that there are some more precise rules nowadays in some rules of the different bar associations. But are there any rules, or what is the role of arbitral institutions in your view regarding the potential duty of technological competence of arbitrators? And how do you think this duty may affect the composition of arbitral tribunals? Maybe
so there's different things that arbitration institutions can do. For instance, the Vienna Arbitration Center has a legal tech think tank that groups together different professionals who have either a specific interest in tech or a specific experience. And one of the things that'll be really important, and where this is also where we can draw a line between sort of general tech knowledge, kind of, 20 years ago, you'd say, I know Microsoft Word or Excel on your resume. So that's kind of, let's say that's the general tech knowledge, for example, doing a Zoom hearing. But then it'll be very important that these institutions also keep lists of people who have specific experience, whether it's in artificial intelligence or blockchain or smart contracts or crypto money disputes. And we are seeing that. And in addition, there's also the Silicon Valley Arbitration Mediation Center. And there are certain institutions like JAMS and the American Arbitration Association that are kind of getting very specific experience, because their institutions are very often put into arbitration clauses in terms of use agreements by blockchain companies. So I think in the future, this kind of knowledge and sort of the procedures will be more institutionalized. And it's very important because it's very difficult for a client on their own to find competent arbitrators.
Thank you so much. Andrea, what is your view about the role of arbitral institutions?
Well, I can just second what Anja said. I mean, arbitral institution put also in their rules that arbitration have to be conducted efficiently. That's just one of the ways. So if an arbitration institution appoints an arbitrator, this arbitrator has to have the very basic technological competence Anja and I would agree on. And then, of course, if it's a tech-related dispute, then the arbitrator must have a certain competence in that regard too.
Great, thank you so much. And we know that both of you have a lot of experience as both counsel and arbitrators. So could you please share with us some maybe practical examples of cases in which you felt a particular need to be on top of technical issues, and then some technical competence and not just legal competence was particularly required?
I mean, on my end, I'd say definitely crypto disputes, because crypto is a newly emerging thing. So, and it's treated differently in different jurisdictions. So, for example, we always talk about cryptocurrencies, but not all jurisdictions will treat them as currencies. It's not the same thing as sort of asking for dollars as compensation. Sometimes they're treated as digital assets. Sometimes they can be treated as securities based on the specific properties that they have, and an arbitrator has to realize that. And in addition, there's also the issue of how do you evaluate damages in crypto, because obviously you can, on the one hand, kind of say we're going to convert this into dollars, but then since most of these cryptocurrencies are extremely volatile, it's difficult to pinpoint a date that of the valuation, because very often Bitcoin will go down, it will just like take a nosedive, and then 2 weeks later it's the best it's ever been. So those are specific technical difficulties. And in addition to that, in many cases the claimants will actually want the crypto back, and since each crypto coin is registered on the blockchain with a specific sort of code, you can argue that they need that specific crypto back, and that again leads to different issues. How do you track it down? How do you freeze it in a specific wallet once you have tracked it down? So arbitrators, I feel, would need some pre-existing knowledge about these technical aspects of this specific commodity in order to make a reasoned decision.
Thank you so much. And what about Andrea?
Yeah, the practical example I have seen in person is the dispute revolving around the migration of a software system. Construction of software, also migration project of software. So on the surface of the dispute, it may seem that it just concerns a simple contract interpretation. But in order for the judge or the arbitrator to properly construe the contract and properly define the parties' obligations of the contract, I think it's crucial to have an understanding of the underlying technological issues. So the case I have been involved with, I was acting as a counsel for a tech firm that was tasked with the migration of a core software system of the company. The idea was it was an old software system containing 3 different coding languages, very old architecture, and the idea was to migrate it into a modern environment. So one of the crucial questions, technical questions, were which party is responsible for defining the architecture of the software. You can have understand the architecture software is like the blueprint when you construct a building. So it gives you the information where you put the windows, where you put the doors, where you have all the electrical cables. And certain elements of this can be defined by the tech firm, but certain elements have to be defined by the company that uses the software or is the owner of the software. For example, when you build a house, you as the owner or as the person who's going to live in that house, you want to have a say where the door is. But depending on where you choose to have the door, then you also have to put the window somewhere else, or you have to put the pipe somewhere else. And that's also very similar issues that can arise when it comes to software architecture. So in a dispute like that, we as the council, we had to translate these technical issues into a language that was understandable to the judge. In that case, we were before a Swiss court. But if we were before an arbitral tribunal, what I would expect and what I would wish is that the members of the arbitral tribunal already have a basic understanding what role the architecture plays when you construct or migrate softwares. At least, as a minimum, what I want is that the arbitrators are tech savvy enough to be willing to learn on that topic, even if they don't have previous experience.
Thank you so much for this very interesting and insightful modern practical examples. In the interest of time, I'll actually have some more questions, and I hope our audience too, but we'll have to move on another link for a Q&A session. And thank you, Anja and Andrea, for an insightful and practical discussion. We would like to conclude this first part of our session by thanking our partners, 𝗔𝗥𝗕𝗙𝗏 and the Lagos Chamber of Commerce International Arbitration Center. And to see future arbitration and briefs videos, please follow us on LinkedIn, like and subscribe to our YouTube channel. And we will also love to hear your comments and feedback. And the next episode will take place on the 1st of May and will concern the question of how to deal with non-paying claimants and respondents. This will be an episode by Amanda Lee and Soraya Korn-Ballos, moderated by Azil Zimo. And now for everyone who would like to join us for the Q&A session and ask some more questions, everyone can join us and ask any questions you might have. There is a link in the chat that you can click to move on to the non-recorded part of our meeting. And we hope to see you all there very soon.
See you in a sec.
See you in a sec. Thanks for having us.